SJC-13447, Commonwealth versus Epshod, Jeune.
Attorney Rappaport, welcome back.
Thank you very much. It's nice to be back. To please the court, Stephen Rappaport on behalf of Epshod, Jeune. The focus of this argument today is going to be on the prejudicial impact of the erroneous admission of the O'Brien testimony.
Can I ask one, before you get too far, Fisher has been decided.
Yes, I know.
And these issues seem to be almost exactly the same as Fisher. So when you distinguish the argument here from what we've already decided, that would be helpful, at least for me, because we tend not to change our minds within a couple of months, right?
And I understand that, Your Honor. I had the advantage, of course, of watching the Fisher argument numerous times, and I think I know.
But you also have the advantage of reading the Fisher decision.
Oh, absolutely,
right,
Judge.
okay.
And I'm going to comment quite a bit on that.
Go ahead.
If I may,
I
your
don't mean to
question
cut
is
you
an
off.
interesting
It's just-
question.
yeah.
How is this case different than the Fisher case? In this Passover Easter season, I'm about to sit down at a Seder, and somebody's going to ask that question, Manish Tanah Halayla Hazeh Shukal Halilos. Why is this night different than all other nights? Well, I was actually thinking of that as, how am I going to deal with this case? Because this is not an easy situation for me to be in, arguing on behalf of Mr. Jeune at this time, but I do believe I have certain advantages. For instance, a major part of Fisher's argument had to do with whether or not it was erroneously admitted, whether this evidence was erroneously admitted. And there was quite a bit of back and forth as to, well, the prejudicial impact versus the probative value. I would submit, I don't know whether this court found the admission of the evidence erroneous because the prejudicial effect outweighed the probative value, or because there was absolutely no probative value in that evidence.
But the evidence being O'Brien's narrative versus the video.
Exactly. The video is clearly valid evidence in the case, and even—
I don't know if we did a 403 analysis.
Well, Justice Georges was questioning counsel.
I would go, well, I would go by the written.
No, I'm just saying.
The opinion, because I think what the opinion says is that it was erroneous for O'Brien to narrate, period. Not
right,
whether
because this was something.
Not
well,
whether
wasn't that
there should be a
narrate
403.
for him to make the identification to say those are the guys? Yeah. It's perfectly all right for him to say, for instance, look at the clothing here.
Right. I think
look at the clothing here.
So, assuming that we think it was erroneous, that there was no balancing, as you're suggesting, what makes this case different? Why is
okay.
Which I think is where you started, which is why the prejudicial effect.
There are two major differences. One is the nature of the defense, and the second thing is the most important video in this case, the Burlington video, where the homicide occurs. It absolutely, with regard to the second individual alleged to be Jeune, it was hopelessly obscure. There was just no way of making an identification of that individual from that video. And frankly, look at what happened at Burger King. This was the first time that there's this actual face-to-face meeting with the individuals. The first thing that O'Brien does when he has Fisher get out of the car is he pat-frisks him. Why does he pat-frisk him? He pat-frisks him because he recognizes him. This is what he says: I recognize him from the video as this fellow who was walking into the hotel. Did you pat-frisk Jeune? No.
But wouldn't whether he's obscured or not, go more towards whether or not he can give an opinion? We already
he shouldn't be.
I think everybody agrees, and hopefully the Commonwealth does too, that that shouldn't have happened. In all our case law and the appeals court case law on whether or not it's a obscured versus a clear video goes into whether or not someone can do it, and in here,
okay,
clear,
fine. And
couldn't do it.
So now we say he can't. I think you were the first justice to raise the issue of the limiting instruction in this case, and saying, well, in Wordsworth, we didn't have a limiting instruction, but in this case, we do. And frankly, that's not true. There was no limiting instruction in this case.
I thought, didn't Judge Henry say, hey, that's your call to the jury, essentially?
No, that's not what he said. That's part of what Justice Henry said.
Right.
And certainly in the opinion in Fisher, this court said that the most impactful factor in determining that the admission of the testimony was not prejudicial was this limiting instruction. But let's look at the limiting instruction. First of all, the timing of the instruction. O'Brien testified over 3 days, extensive testimony. Day 6 of trial, he was talking just about the Keurig video. He wasn't talking about identifying either of the individuals. But on day 7, long direct examination with numerous references to these being the guys. Day 8, once again, long direct examination as to these being the guys.
That's because there's a lot of evidence that these are the guys, and
Well,
particularly about your client. I mean,
My client was involved in this joint venture.
so
I've
then what are we?
Let's keep on track, because we can get to
Go
that.
ahead,
So,
go ahead.
okay. So
what's the fault of the limited instruction?
this is what he says. Well, first of all, it's the timing. It's one thing to say to the jury right now, ignore the elephant that walked into the room just now. It's another thing to let the elephant sit in the room for 3 days and then say, oh, by the way, ignore that elephant that came into the room. And that did pretty much happen in this case.
It was too late.
Certainly too late, I would submit. But the first instruction given to the jury was as follows. O'Brien's testimony was offered for whatever assistance it may provide you in making your determinations. You may consider O'Brien's testimony regarding the identity of those persons in the video and give it whatever weight that you deem it fairly is entitled to. This was the first instruction. There's no limitation on the use of the evidence there.
Well, it's the last thing he says, though.
Well, you have to make your own determination. And in fact, I think in the Fisher opinion, that was underlined. I have and it's part of the record, I believe, the jury instructions in this case, nothing's underlined. How would a reasonable juror take this instruction given by Judge Henry? He's telling them, you don't have to use it. You still have to make your own decision, but you can use this in any way that it may help you. If you take a look at what instruction is given in every single Superior Court criminal case and was given in this, the general instructions to the jury are, you are the sole and exclusive judges of the facts. You alone determine what evidence to accept, how important any evidence is that you accept, and what conclusions you draw from the evidence. That's given as boilerplate to every jury. And that's what this instruction said.
But Judge Henry does, first he says, you are not bound to accept that testimony. And dude, you must make your own determination as to what you see.
As you have to do with any evidence.
And then in the concluding instruction, he goes, if you conclude that he intended to tell the truth, you must also consider the possibility that he made a good faith error in identification. You know, and we got the honest mistake.
Don't we have to do that with considering the credibility of any witness? The witness may be lying, but then again, the witness may have made a mistake. These are general instructions given to a jury. This did not limit in any way. In fact, Judge, there's three times, in addition to the first time at the end of direct examination of O'Brien, there are 3 more times that the judge says to the jury, and these are his words, you must give the identification testimony of Trooper O'Brien whatever weight you deem it's fairly entitled to receive. You heard the testimony of Trooper O'Brien, who identified persons.
Can I shift you just a little bit? Because there's just so much evidence that, and our opinion makes this point, that your guy is there, and
Where's
he's-
there?
He's in all
This is-
three places.
What's the scene of the crime? Is the scene of the crime the hotels, or is the scene of the crime the room?
To be clear.
I mean, seriously, Your Honor, which is this? According to Fisher, the scene of the crime is the hotels. I wasn't there. I had nothing to do with this. And the evidence was overwhelming that he was as well involved in this scheme.
So does that dovetail in one of the first things you said on prejudice was the nature of the defense? Then you went
Absolutely.
Then you went into obscured video and then the limited instruction. So get back to nature of the defense.
Nature of
How
the
is the
defense
nature of
here?
the defense distinguish this from Fisher?
Well, Fisher's defense was, I wasn't involved in this in any way. That's what his defense was. I'm not the guy that appears in any of those videos.
Right, and so how does your client's defense differ?
I wasn't in the rooms. First, let's start with Gattuso.
Your
Gattuso
defendant defined the
described-
scene of the crime as the room, and he was maybe at the hotel, but not in the room.
Absolutely. In his opening, and certainly in his closing, defense counsel says, look, a reasonable verdict in this case would be guilty as to robbery of Gattuso because he's involved, and
He has her-
guilty
he has-
of the
He
homicide.
has her credit cards, right?
Everything, Judge.
okay.
This was, if I tell you overwhelming, I try cases. If it wasn't for Commonwealth versus Brown, this would have been a long guilty plea. I mean, seriously, if not for Commonwealth versus Brown, at least defense counsel recognized, wait a minute,
You lost.
Brown may be a game changer depending upon a person's role in the offense. Might a jury say that the getaway driver or the lookout is just as guilty as the person in the room? Certainly. But they also might say, well, wait a minute, knowledge and intent really matters here. Somebody's out in the getaway car. Somebody's down the hall as a lookout.
I'm confused.
That's
Meaning
very
that-
different.
Meaning that you're suggesting there were 3 people involved in this rather than
Maybe
2?
as many as 4. We know there's at least 3 people. That's a given, and the Commonwealth concedes.
The only reason we know there are 3 people, or you can make an argument that there are 3 people, is when they get to the car, there are 3 or 4 people in it. But all
No,
of the
no, Your Honor, if I may.
Go ahead.
The videos show that as 2 individuals leave the car, and the 2 individuals who are alleged to be Fisher and Jeune leave the car and walk into the hotel, the car is moving around outside. And O'Brien admits it. He actually says it. Well, obviously, there's at least a 3rd person involved in this, and I submit to the court, there's at least a 3rd person. We don't know if there's a 4th. Is there a getaway driver and a lookout? I mean, the nature of these crimes, one would think that you would want to have a lookout. These hotels look very, very busy, people coming in and out. It wasn't that late at night. It is a time when people would be coming in and out. I mean, the point is, yes, he was involved. From day one, in his opening, I think defense counsel said something like, well, if you don't think the police planted all this evidence, you're going to come back with this as your result. But what happened here doesn't say anything about what happened in Johnson's room. Johnson's room is the crime scene. If my client is driving his car that night, especially at the Burlington Hotel, where he's well known by everybody who works there, was the local marijuana dealer at the hotel, and everybody staying at the hotel who smoked marijuana knew him. Why would he be the guy that goes into the hotel?
Well, isn't he the guy who comes in through the side entrance, not in the front entrance? Or
He's
I got
supposedly
that back?
number 2. He's supposedly the fellow that comes in the side entrance. You cannot make out a face. All you can see is a dark hoodie, a cap, dark pants, and dark shoes. The gait of the individual was a major factor that O'Brien used to try to compare. Well, look at this guy in Saugus, look at this guy in Woburn, and look at this a video of the defendant at work in Waltham. You can't do that with the Burlington video because it doesn't show the gentleman's gait in any way. All you have is this person coming in a black hoodie, dark clothing. You can't tell anything about the way the person walks from that particular video. So the main difference between this and Fisher is the nature of the defense. Yes, it's a joint venture. Yes, my client's involved in a joint venture, but he wasn't in the room. First, we start with Gattuso. Gattuso describes an individual very different than, as the second individual, very different than Jeune. First of all, clothing. The Commonwealth's alleging that the person that went into the room was wearing a black hoodie. Gattuso says, no, it's a gray hoodie. She's off by at least 5 inches with regard to the height. Facial hair. We know that Jeune at the time has facial hair. This woman is talking about the man's complexion, but he didn't have any facial hair. Tattoos. We know Jeune is heavily tattooed on his hands. She says, I didn't see any tattoos on his hands. Well, he was probably wearing gloves, as one of the people in one of the videos is shown to be wearing a glove. Nope, he wasn't wearing gloves. The argument was, wait a minute, that's not Jeune in the room. Not that Jeune's not involved, not that Jeune doesn't show up on one of the videos at that particular hotel, at the Woburn Hotel. He's identifiable in one of the videos, but he's not the man in the room, according to Gattuso. Well, what does the Commonwealth say about that? I know that one of the factors that the court looks at in situations like this is prejudice. What did the DA say in her closing? Well, Michelle Gattuso has her memory in her mind's eye. The police have the video later on. The police took the time to examine the videos. I know that one of the issues in Wadsworth was, well, there's 4 guys, and that's, Judge Kafka, you actually picked up on that. 4 witnesses in Wadsworth versus 1. Well, not according to disclosing. She didn't say, well, O'Brien had the video. The police have the video. She's implying that there are more than one person who could provide this information. Nobody else testified about any videos in this case. I submit that that kind of takes it out of there's just one person giving the testimony.
Can I ask about the baseball hat? Was there something distinguishing about the baseball hat?
In the Burlington video, you can't see the baseball cap. You can just see the brim. You really don't see anything. Mm-hmm. There may be a sticker, but you really can't tell. In the Woburn video, which basically O'Brien identifies him from the Woburn video and then says it's the same guy there. But you can make an identification of him from that video, and he is wearing a very distinctive shirt. He's wearing a very distinctive cap. That cap, I don't believe, was ever recovered. They do recover an A's cap. It supposedly had like an Oakland A's baseball cap, but it was a different color. The cap that they recover from Jeune's house was a different color than the hat in the video. Number one. But there are photos of Jeune wearing the T-shirt. There's no question that Jeune is depicted in that Woburn video. There's a substantial question as to whether or not he's depicted in the Burlington video, and quite frankly, Jeune concedes that he's involved in the armed robbery of Gattuso. I'm not asking that the court reverse that conviction. I am asking the court to reverse the murder conviction because the evidence is very, very different as to Burlington. I do want to say a few things, if I may, before I finish. First of all, O'Brien's testimony wasn't cumulative. He was the only person who identified Jeune as being the person in those videos. It wasn't collateral because, as I say, Jeune had conceded early on, yes, I'm involved in this particular crime, but it goes to his identification of him as being the man going into the room. So it's not collateral. The imprimatur of the super witness, if you will, I think it's particularly bad in this case. First of all, we know that O'Brien is the, if not the lead, one of the lead investigators in the case. I think what sets him off from other police officers, though, is the fact that he was excluded from the sequestration order. And he's in and out, and he admits that he's in and out of the courtroom throughout this entire long trial. He may be viewed much more as a member of the prosecution team than as just a mere police officer. And I submit that that also gives him enhanced credibility, including how many times he says he's watched it. I already mentioned the closing argument where I believe, once again, it almost takes it out of the one witness situation and says, well, there are many witnesses who could tell you this. And finally, I have to come back to the limiting instruction. You know, there was evidence in this case about the Saugus attempt with one of the sex workers. The defense had objected. It was prior bad act evidence. So what you have is during, or I should say, prior to the testimony coming in about Saugus, you have Judge Henry saying, there's evidence of conduct, must not be considered to prove the defendant's bad acts, only for a limited purpose. At the beginning, prior to the testimony, he says, I'm giving you this instruction at this time because the testimony that you are about to hear is being offered only for a limited purpose. I want you to understand the narrow nature of the purpose. That's a limiting instruction. That is a limiting instruction. It says, this evidence may only be used for this purpose, not for this. There was no limiting. There absolutely was no limiting instruction. And yes, Judge, you're right.
Just have one final question for you because you're over. So the Woburn, you say there's no question your client is in the Woburn room, right?
No.
But
No question that he's involved in the Woburn case. He's seen approaching the hotel.
So there's not.
And by the way, O'Brien says.
So you're saying he's not in the. You're saying when we read through this whole record, we can't determine that he's the guy in the room in Woburn as well. Because if he is the guy in the room in Woburn, we know the guns used in the room, guns pointed at the person's head. So if he's involved in that one in the room, can't we find the necessary intent for felony murder even after Brown? Because he knows that guns are being pointed at sex workers' heads in the other one.
Well, now you're making a determination.
Well, I'm just using what you're conceding, and I'm trying to understand what you're conceding. Because unlike your briefs, you've come up with a new theory.
Well,
that's not in your briefs. So I'm trying to respond on the move here to what I didn't see in any of the briefs.
Okay, and Judge, in a sense, I must apologize, but in a sense, when you prepare for oral argument, you see things you've never seen before.
We're down this road already. So I'm just trying to get a sense. If we find he's in the room in the Woburn one, and there's sufficient evidence of that, and it's a pointing a gun at the head, threatening to shoot, basically blow your head off kind of robbery, isn't that going to be enough for the felony murder conviction here?
I don't know. Mm-hmm. I don't know because I don't know how a reasonable juror would have looked at it. What I do know is that a reasonable juror was told, you can use this for whatever purpose you want. So there is really no limiting instruction. And the overwhelming evidence of guilt as to Mr. Jeune in this case is that he was involved in a joint venture to rob various sex workers. What's not clear in this case...
With a firearm.
Excuse me?
With a firearm.
With a firearm.
Right.
Okay. What's not clear in this case is whether or not he was one of the two people in Gattuso's room, because frankly, not only she described somebody very differently, She fails to pick his photo out of an array. I know that the Commonwealth argues, well, he was younger than. She picks out an entirely different individual. I would submit that the evidence that he's in Gattuso's room is far from overwhelming. And there's no evidence that he's in Johnson's room. The evidence is that he was engaged with others in a scheme to rob various sex workers. He's guilty of the armed robbery for sure. He's guilty of the attempted armed robbery for sure. He's not necessarily guilty of the homicide and certainly not murder if he's not in the room. I'm not saying he couldn't be found guilty of murder, but he's not guilty of murder. There's no way you can say that if he's not in the room, that he knew and he intended what happened in that room. So yes, the crime scene, as far as Fisher was concerned, I'm nowhere near this. I'm not involved.
Okay, but you don't have to be.
No, you don't have.
Right,
but
right.
But
No,
post-Brown.
I'm just trying to get to the point that we're almost 6 minutes over. And
I'm
if
sorry,
there's
Judge.
nothing else that you have, I think we get it.
Okay,
No, you've done a very good job of getting your point across. I appreciate it.
thank you. I appreciate it.
Okay, Attorney Elliott.
Good morning. May it please the Court. Assistant District Attorney Krista Elliott from Middlesex on behalf of the Commonwealth. I'm going to turn first, as my brother focused on, to the identification issue, but I do want to first note that the defendant's defense at trial was not that he was not in the room. Rather, if we look to the defendant's closing, at the very beginning of his closing, he defines the key theme of his closing by saying that the theme is, quote, wanton and reckless conduct is not murder. If it results in the death of a human being, it is manslaughter, but it is not murder. And then closes out the closing by saying, quote, if you come back with manslaughter and armed robbery, which has a life sentence, you will have done justice and there will be no winners.
So this was a third prong versus involuntary manslaughter case?
Exactly, correct. This was not there was not a question at trial as to whether or not the defendant was one of the people in the room. There was a recognition that essentially to the jury, as long as you believe the Commonwealth's evidence, my guy was there, was essentially what defense counsel was arguing, but just trying to mitigate the malice throughout. So turning to the identification issue, the Commonwealth does concede that in light of this court's decision in Fisher, that Trooper O'Brien's identification of the defendant in the hotel surveillance footage was error. However, this fleeting singular identification did not prejudice the defendant where the evidence against him was utterly overwhelming, as this court acknowledged in Fisher, and the trial judge gave repeated and forceful instructions to the jury that they alone were responsible for determining the identity of the men in the footage. There was no issue with the instructions that were given. The instructions were comprehensive. They were clearly targeted to Trooper O'Brien. They repeatedly mentioned his name and invoked his names, telling the jurors that they must be the ones to make a determination based on the video alone. And there was no error in either in those instructions, and certainly there was no prejudice based on the
But,
overwhelming.
I mean, it's just contradictory to allow the testimony and then to give the instruction, because to allow him to testify and then to tell the jury, you can consider it in any way you want, but you make the call, then leads to the logical question, then why is he testifying in the first place?
Well, to be clear,
We've already said it's error, but.
So in terms of that instruction, I mean, that is the appropriate instruction to give a witness who is making an identification based on the video. The instruction, and I apologize.
I see what you're saying. If it's someone with familiarity, an appropriate witness, not O'Brien.
Correct, exactly. And because of course, as far as the
Right, so
judge is
given the
concerned,
fact that it wasn't an appropriate witness, that O'Brien shouldn't have testified as he did, the reliance on the jury instruction to say there's no prejudice seems awkward at the least, because, you know, as your opposing counsel has pointed out, they could consider it for whatever value they considered it to have.
Yes.
When in fact they shouldn't have heard it at all.
Yes, and I do want to address both kind of two tiers of points here. The first is that I think it's important to read the instructions in their entirety, because that language about considering it for whatever value you believe it would have is couched within, you are not bound to accept that testimony, and indeed you must make your own determinations, and similar invocations throughout. And so those instructions really do need to be read as a whole, as opposed to having those individual pieces excerpted. But also, in Jeune's case, the evidence against Jeune was so incredibly strong that regardless of whether or not there was that singular problematic
Stronger than the Fisher evidence.
significantly stronger than the Fisher evidence. Here, we had the obvious likeness of the defendant to the person who was in the video. We had his phone and its records for two separate phone numbers. Well, we had one of the phones and then the records for two numbers. We never found the second phone that provided direct evidence of his guilt, including the fact that he had accessed the Backpage.com ads of all of the women who were working as escorts. He had communicated with the victims, and all of his location information for those cell phones perfectly lined up with the surveillance footage that captured his unique vehicle.
He's clearly
Yes.
either the brains of the operation or he's involved in everything. This new argument, though, raises he's robbing his own hotel, which is a little odd that he's running in. So you want to address that, I understand it's new and you're going to have to do this on the fly, but why don't you take a shot at it anyway?
Of course. I think that, we have even with this argument, there is a clear inference that can be made that this defendant was, in fact, in those hotel rooms. I think that the fact that the defendant enters through the side door in Burlington, the hotel where he is known, where he has worked up until a couple days before, or at least relatively recently, is incredibly probative of the fact that he is intentionally trying to hide his person further than he was in the other videos, and does support the fact that he was in fact that person who was in the room. Looking to Gattuso's testimony, there is specific evidence that Gattuso has testified that there were two people who were in her room. The surveillance footage shows two people going from the vehicle into that hotel. It does not show a third person going into that hotel. So the reasonable inference for the jurors is that both of those people that are observed going into the hotel in Woburn are in fact the two people that ended up in Gattuso's room, regardless of whether or not there are any discrepancies.
And is the hat distinctive? The hat seems to be important. Is that the video shows some very unusual hat, and is that the same hat found in his house?
I would have to double check. Certainly that hat has been admitted into evidence. It was not something that I specifically focused on. There was absolutely an A's hat that was found and then admitted into evidence. That was found in at Jeune's house after the execution of the search warrant, but I would have to review the record again.
And from what I remember, Gattuso, this guy has all these tattoos on his hands, including distinctive ones about Haiti and some other things. But she doesn't she says there are no, does she testify that the person has no tattoos and is not wearing gloves? I can't remember.
I believe she did testify to that. That was part of her testimony. I think that it is important to remember that this is a woman who interacted with these two men for, as she testified, between 3 and 4 minutes in an incredibly high stakes environment with a gun trained to her head, and for much of the time on the floor. The fact that there are inconsistencies in her description is not particularly surprising.
Is the Commonwealth theory that he was the shooter?
Yes. The Commonwealth did not have a specific theory. That was what the jury came back kind of indicating.
But didn't they come out the opposite, though? I thought Fisher is the principal. Who's found to be the principal in this? I can't remember. Was it Fisher or Jeune? One of them has a principal conviction, and the other only has a felony murder conviction, right?
They're both felony murder convictions, Your Honor?
No, they both have felony
Yeah.
murder. I thought one also has a principal.
Well, Jeune had, I do apologize, I don't have the verdict slip in front of me at the moment, but Jeune was found guilty of possession of the firearm, whereas Fisher was not.
But he had the ammo in his house.
He did have the ammo at his house. The impression based on the verdicts was that the jury believed that Jeune was the person who fired the gun. But regardless of who it was that fired the gun, does not matter for the purposes of joint venture felony murder.
Right. Was Fisher acquitted of possession of ammo or of possession of a firearm?
Yes. I believe that it was a not guilty on the possession of the firearm. I would double check the record, but that is my recollection for Fisher. If there are no further questions on that issue, I would simply note that the bulk of the rest of this case is really controlled by Fisher, with the exception, of course, of the possession of the firearm charge, which the Commonwealth has conceded does need to be remanded pursuant to Bruin and Guardado 1 and 2. If there are no further questions, I would rest on my brief.